Yes, Mr. Dwivedi.
Great. But I was at page 10, last line of my submission. There's only 3 more pages and then I conclude. D, Lord, at the bottom.
Okay.
After 1996, Lord, I've given the issues settled in that case, Lord. 1996 Labad 135, Lordship, sir. I've already referred to it. And this is, as I indicated, Lord, approved in Seal's case, Lord, 98 Supreme Court. Then Belson also, 99. And ITC, which I have given in the page 13, 12.
Yeah,
I will kindly come to paragraph D, item D, Lord, page 10 at the bottom. Of written submissions, which Lordship was seeing. Scope of inconsistency or conflict, which was very seriously addressed by my friend. Does it require that the field ought to be actually occupied? Because according to my friend's argument, there's a code by itself laid down, IDR Act, and therefore. But this concept of code vis-a-vis IDR has never been accepted, because fact is the entry 52 is very limited. Doesn't cover the raw material nor the end product. So therefore, IDR by itself regulates production as per the constitution. Now you may not infiltrate onto other topics incidentally and otherwise to the law, but then actually the term industry denotes, and which Rochester has seen host of cases. Now, Lord, the claim of the union is that Parliament has evinced an intent to cover the whole field, and therefore, even if no order is issued under Section 18G, it makes no difference. It is the occupation of field by abstinence or forbearance. For this, they have relied upon the cases, following 2 cases relating to mines and minerals. But curiously, as I said, it is quite uncanny that every time when this question is raised about the expanse of entry 52, to cover both the raw material and the production, then they invariably go on to the mines and mineral cases. And Lordship would see right from 56 onwards till date, there has been quite a distinction drawn between the 2 categories, 52 list 1 and 54 list 1. 54 list 1 relates to entry 23 list 2, and 52 list 1 relates to entry 24 list 2.
Yes.
Now, Lord, entry 23, as I had indicated, if your Lordship would very kindly come to this 96. And these are the 2 cases, Lord, which are invariably referred to. Invariably. And this is what is explained here and approved by Lordship in Supreme Court. It is PDF volume 5. PDF volume 5. PDF page 2274. The relevant paragraphs are paragraph 54 to 57. 69 to 72 of the PDF. And again, those 2 cases are referred. And then can you have paragraph? Can you have 71? That is PDF page 2294. I'll place only these 2 paragraphs slightly, then move on. The cases referred to above relate to grant of leases. Have Lordship heard? Imposition of cess and royalty and collection of fee in respect of mineral rights and mineral mines and mineral development regulation act. No doubt these cases at first sight support the contention of learned counsel for the petitioners.
Mr. Dwivedi, which para you are reading? I'm just para.
Para 70.
Volume 5,
2274.
2294. 2294.
229.
May I place it? No doubt these. I'm sorry.
229.
It's not there.
Yes.
Shriram Industrial.
Shriram Industries.
Correct.
That's 74.
227. 229.
May I proceed? No doubt these cases at first sight support the contention of learned counsel for the petitioners, but on scrutiny of the relevant entries of the Schedule 7 show that the cases relied upon by the learned counsel for the petitioner are of no assistance for the proposition of law advanced by them. The cases referred to above relate to entry 54 of list 1 and entry 23 of list 2 of the 7th schedule. The perusal of entry 23 and 24 would show that entry 23 of list 2 is entirely different in its content than entry 24 of list 2. Entry 23 of list 2 deals with the regulations of mines and minerals subject to the provisions of list 1 with respect to regulation and development under the control of the union, whereas entry 24 of list 2 relates to industry subject to entry 7 and 52 of list 1. On comparison, it will be found that the entry 23 of list 2 deals with mines and minerals, which is industry as well as product. Whereas entry 24 deals with industry only and not with the product of the industry. Since entry 23 is subject to the provisions of list 1 and as such, as and when the Parliament enacts any law under entry 54 of list 1 for regulation of mines and mineral development, the contents of entry 23 relating to mines and minerals shift to entry 54 and thus the state legislature is denuded of its power to enact any law on the subject. That's the case because there the entry is wider. Now, my lord, kindly bear in mind, Lord, there was an observation in the Hingir Rampur's case and Tulok's case that even if law is not made, rule is not made or regulation is not made, field will still be occupied because of the Composite Act. The reason is this, Lord, because nothing is left for the state. The entire entry goes to the center. Once a declaration is made under entry 54, both mines and the product both go to the center. What is the state going to legislate on? They are totally denuded. And therefore, whether they make the rules or not, or regulations or not under the law, it makes no difference because there is no scope available in the state list. The list itself goes, the item itself goes to the center. So therefore, this reliance on this theory of code by itself and therefore perhaps the entry, when the field is occupied and the legislation by abstinence therefore will hold the field is not correct. This analogy with the mines and mineral cases is totally incorrect. Secondly, Lord, what is important is, if you see section 18G, for a moment.
Does not apply here also.
Of the Act, not IDR Act. Do your lordships have it, or should I give the volume number? Lordships have. Power to control. Kindly see what chapter says. Control of supply, distribution, price, etc. of certain articles. Power to control supply, distribution, price, etc. of certain articles. 1. The central government, so far as it appears to it to be necessary or expedient for securing the equitable distribution and availability at fair price or any article or class of articles related to any scheduled industry may notwithstanding anything contained in any other provision of this act by notified order provide for regulating the supply and distribution thereof and trade and commerce therein. So what does it say? Not I ask myself, but it says by a notified order, you can provide for regulating of supply and distribution, trade and commerce of the commodity, the product. Now, the control has to be exercised through an order, which has to be for regulating. But if the center doesn't use this power and keeps silent, or as my friend said, abstinence, does it mean that it wants to regulate or it is regulating the supply and distribution? It's a positive order which is incorporated, which is required here for purposes of regulation of industry.
But the center not regulating by a notified order is also consistent with its having formed an opinion that it is not necessary or expedient for securing the equitable distribution and availability at fair price.
I'll answer that.
It's not just an issue of forbearance. The center may feel that the conditions
I'll ask
precedent
that.
are not satisfied and therefore we will not regulate.
Fair enough. But then
Then can any other authority say that, look, according to us, the conditions are requisite are satisfied?
no, when the question arises of a conflict with the state jurisdiction and the central jurisdiction under 1933, then there must be much more than what the center tries to indicate by abstinence. There has to be some indication. If the center wants to regulate by no regulation, then it must pass an order and say so. But it does not mean that I am not going to regulate and I would not allow others to regulate also. Your Lordship would recall that statement of just Mr. Govind Vallabh Pant, the paragraph which my friend had relied upon. While answering the queries, what he said was, we believe in cooperative federalism and therefore we want to leave space for the state. We want, because these are the matters which are locally better understood and locally better managed. Therefore, we want to leave it. So,
Basically, basically.
kindly have note 18G provides explanation. Where will it lead to? In this section, may I kindly have the explanation? In this section, the expression article or class of articles relatable to any industry, a scheduled industry, includes any article or class of articles imported into India which is of the same nature or description as the article or class of articles manufactured or produced in the scheduled industry. Now, here is a case where imported article is taken in. That is not manufactured in India. Obviously, industry will not take in. The word industry cannot visualize such an article because it is not produced here. Now, question is, you don't regulate, you don't allow states to regulate. For instance, take the clause 18G2A. For controlling the prices at which any such article or class of articles may be bought or sold. Controlling the prices. Now, Your Lordship has seen that under the Constitution, price is entry 34 in the list 3. State can exercise the power. But by doing this, what you are doing, by abstinence, you are saying even state cannot fix the price of the imported product as well as the local product. Not, as I said, not 33 has to be read in the sense of a cooperative federalism, where some space should be left for the state, as I praise that portion of Sri Govind Vallabh Pant.
But if it is a declared industry under entry 52, the power to regulate prices will be traceable to entry 33.
34.
33.
No, it may not, because there is a
Because
specific
trade and commerce in. Trade and commerce will include all facets of trade and commerce.
No,
34 says price control.
34 says price control.
so which means not
Price control is not abstracted or accepted away from entry 33. in respect of declared industries,
Whether or not-
all trade and commerce will be governed by entry 33.
I would not make
That
an
would
issue on
include the fixation of price.
There's no issue on that. You included in entry 33, you included in 34. It doesn't matter because jurisdiction is the same for both.
Correct.
Both the state, center and the state will have the jurisdiction. What I'm saying is the consequence would be that once you lay down a law broadly and provide for making a regulation, don't make a regulation and say that, for instance, Essential Commodities Act. Lordships have the experience of Essential Commodities Act deals with foodstuff. Now, foodstuff, there they have this section 3 which says central government will make rules, I mean the order, issue orders to regulate the supply and distribution and price of the commodities. But supposing center doesn't make anything, but would the state be
No,
deprived?
the center doesn't make it because it believes that the conditions precedent under subsection 1 are not fulfilled.
Issue,
Then, if we allow the states to do it, that would really defeat the purpose of entrusting to the center the power to make that
as I
condition
said,
precedent.
when
The determination on the condition precedent.
therefore, as I said, when we read it, we should not read it from the point of view of the center only. When we read the list 3, then we have to keep in mind that what was there in the mind of the framers. Now, if I may place that, not just for the sake of argument, but kindly notice that the written submission of
Okay, this law will cover not only electricity, but
पेज क्या था उसका? Lord, kindly have page 14, page 12 of the
Station also.
written submission of the solicitor. This is volume D. D for Delhi.
No, right.
Starts at 14, page 14. Lord, I would answer this in two ways. Lord. One is my angle of cooperative federalism, where the framers themselves left the space despite entry 33A. And the other answer to that would be, Lord, that this issue has been settled at least in 10 cases and has been consistently approved by our lordships, that the conflict has to be in fact, direct and in fact, in real terms, and not in possibilities. Now, before that note, I'll place this. Volume 2D, page 14, at the bottom, Govind Ballabh Pant. PDF page 20. PDF page 20. It is of great importance, not what they have said. And that is in the context of 33A, this 3. Sir, may I place it? Sir, all the 4 amendments, so and so and so, are interconnected and interlinked, and they must stand or fall together. According to the bill, development of industries where development under dominion control is declared by dominion law to be expedient in the public interest. Regulation and control of such industries, trade, commerce, whether or not within a province, in and production, supply, and distribution of products of such industries were to be included in list 1. That is, all these subjects were to be brought within the exclusive jurisdiction of the federal legislature and the federal government. Now that would have led to several other difficulties and complications. We all realize that so far as the development of industries where development under the dominion control is declared by dominion law to be expedient in public interest, and regulation and control of such industry should rest in the center, According to the entry already contained in the federal legislative list, development of industries where development under dominion control is declared by dominion law to be expedient in the public interest is already included, and there is no intention of making any change so far as that is concerned. But as proposed in this amendment, regulation and control of such industries should also be placed under the jurisdiction of the federal legislature. So far as the first two parts of this clause are concerned, they will stand as they are. But with respect to the rest, that is trade and commerce, whether or not within a province, in and production, supply and distribution of products of such industries, it is proposed by the series of amendments to which I referred at the outset that these should be included in the concurrent list and changes should be made in other amendments. Now, why is it that they said? Now, this would have led to several other difficulties and complications. We all realize that development of industry is essential, but then both state and center should participate. Why should center say that we'll only deal with it and rest you can't touch it? Otherwise, what the consequences? Now, kindly have this again further note, last line of this, last 5-6 lines. So if these are made the exclusive charge of the center, then the provinces will not be free to discharge the duties and obligations which will necessarily devolve on them. In order to enable the provinces to play the part subject to the overriding powers that will now vest in the center, it is necessary to include these items in the concurrent list, and that is what I propose. Even now, when we have got the Essential Supplies Act, center generally frames a few basic rules and leaves the rest to the provinces. Then in the end, last 4 lines, but they require a very extensive network, and I think it is not possible for the center to manage these things without the active cooperation and support of the provinces. So I propose that the amendment to which I have referred to at the outset be accepted unanimously, and it was accepted. Importantly, my lord, if your lordship would go back to my written submission, sir. Last paragraph, page 11, last paragraph. At least leave the middle paragraph. What we have to see, have your lordship heard?
Yes.
Page 11 of my written submissions. Volume 1A. What we have to see is whether for inconsistency or repugnancy to operate, the field has to be actually occupied and not in the realm of possibilities. It is in this respect the theory accepted is that there has to be actual occupation of the field for inconsistency to occur. In other words, there has to be a regulatory order dealing with trade and commerce, supply and distribution. Under Section 18G of Article 254, repugnancy to occur. For Article 254, repugnancy to occur. To come to a conclusion of repugnancy, the field occupied by both the laws has to be analyzed. Now, these are the cases which have approved the Tikaramji's principle. Not, if I may submit with respect, not for the purposes of repugnancy under 254, lordships have never used this code unto itself argument, not covering the entire. And that I would show from the latest Constitution Bench Note 2020. What the lordships have accepted the principle that it has to be direct conflict in actual terms and not in the realm of possibilities. This is what the latest Constitution Bench also says, 2020. If I may give the reference one, 2020, volume 9 SCC.
Issuance of a notification.
And I'll come to lordship's judgment, the judgment which was there in lordship's mind in 2012, which my friend relied upon. Lord. That is wholly inapplicable. That was a case under Article 254, where the issue was whether the law which has been made by Parliament, signed by the president, assented by the president, has not been enforced. Now, what is enforcement of law? Conditional legislation, which is more of an administrative function. To make a regulation under 18G is not an administrative or executive function. You're creating a law. For instance, if executive function is so wide, then under Article 223, the power is vested in the executive to make the ordinance, which is equal to that of law. But will we call that executive function as per 162? It's not. These are the functions, which are lawmaking functions ascribed to the executive, which is co-equal to the law. And lordships have always said law made under the delegated legislation made under the law is part of the law. Now, therefore, I would submit with respect, this consistent case of acceptance of this Tikaramji with regard to inconsistency, which my friend says is obiter and was not needed. It's not correct, that is an additional argument given. Your lordships very often give more than one reason for justifying. So Tikaramji has given one reason and then he said that let's assume that to be correct and then see what is the position. And then it said that there has to be actual conflict.
What else?
Now, in Sriram Industries case, very interesting situation arose. I mean, the molasses part. There, the control order was issued under Section 18G, but was not applied to state of UP and Bihar. Now, therefore, the court said, since it has not been applied, there is no actual controversy or conflict. Now, should we now say that even though it has not been applied, since there is 18G, therefore it covers the field, state cannot? The legislation was not to apply the order under Section 18G. Sriram Industries case. Now look at that's why I'm pointing out various situations where your lordship will have to look into the consequence of holding that there is a court by itself argument. An exception may be given to a state in respect of an order under 18G, yet we'll say no, it will apply, state doesn't have the power. So the aspect of total denudation which is there in entry 54 is not there in entry 52. That's what I am advocating. And when it comes to repugnancy under 254, we do not apply the principles of the conflict of entries. In case of conflict of entries, this may be the situation when the entire field is occupied. Therefore, there is nothing left. And lordship has seen the MMDR Act, the earlier bench, how composite that act is. When everything has been taken away by the union, then nothing left for the state to do. Therefore, they said, you make a rule or you don't make a rule, makes no difference. It is in that context. And then, kindly see, as I said, there's a consistent line of authorities, at least 10 cases, where they have approved. And now at this stage, after 70 years, we are seeking reconsideration. In my opinion, with all due respect, Tikaramji is a case which is most well considered judgment, followed in other CVs. And minor tinkering here and there shouldn't take away from the value of that and worth of that judgment.
Anything else now, Mr. Dwivedi?
I'm sorry?
Anything else? Or
Yes. It is accepting this one small 1 minute.
Yes.
There is this judgment, I wanted to distinguish this case, 2012 volume 2 SCC 773, where the law was held to be made as soon as it is passed by Parliament and assented to by the President. Therefore, once the law is made, mainly because it has not been enforced, doesn't mean that the field is not occupied. That was the case which my friend had relied upon. What was the name? My friend will pronounce the name better than me.
Mara Prem Puri.
2012, volume 4. But that is a case where they interpreted Article 254 and found that the word used is law made or making of law. So making of law, the procedure prescribed is passing of the bill and signing by the president. The law is made. Once the law is made, the field is occupied. Enforcement is a mere executive act, makes no difference. But here it is different. Not 18G is not an executive act of conditional legislation. Enforcement is nothing but conditional legislation and executive act. I think that would be. You respect, but that case is therefore totally distinguishable. Thanks. I'm greatly obliged.
Thank you, Mr.
But my friend has covered most of the points, so my role is limited. First, let's get to entry 8 of list 2. And my submission is the end of the day. Lordship has to really decide whether the view taken by Justice Chagla is the better view or the view taken by Justice Fazal Ali is the better view.
That's
And
right.
that's the.
They're really
so-
the two competing views.
Exactly.
Justice Chagla.
So you're not.
You are in a way, Mr. Dwivedi was right that Chief Justice Chagla's view, obviously very weighty expression of authority, but that does not look at the legislative history, which Justice Fazal Ali has done.
Yes.
We really have to still weigh in the legislative history. As
I was about to say that 5F, the judgment starts at page 429 and the operative portion of this is at page 439. And as the Lordship says, my Lord, we are always hesitant to say Justice Chagla is wrong, but then I'd only say that, my Lord, Lordship has not considered the legislative history and he has gone merely by the common parlance test. That's my submission. The Lordship now comes to page 439. Why should we do? View was partly accepted, partly reversed. And Lordship will just come to page 439. I'll just point out the paragraph. I won't read it in detail. And my submission is, apart from not considering legislative history or the use of the term in various excise acts, his Lordship's observation is contrary to the earlier paragraph their Lordships themselves cite in the Bombay High Court. So the Lordship has to compare 5F 439.
But you know, the learned Solicitor General, during the course of his submissions,
Yes.
also dealt with the legislative history per se.
Yes.
You know, particularly in that chapter 4, volume 4B, where he referred to the preamble to the Licensing Act of 1872.
Yes.
And his argument was that it basically deals with drunkenness. Then again, he relied upon Hansard. And the submission was that intoxicating liquor has always been understood, even in the legislative history, as a beverage which has been sold for consumption for human beings and has an intoxicating effect.
That's exactly what Justice Fazal Ali says. He says that under the common parlance test, intoxicating liquor is something of an intoxicating drink. something which is consumed by the human being.
Yes.
So, my lord, the importance of this Fazal Ali's judgment is he noticed this common parlance test. And I think where we are in error is we are trying to interpret a constitutional entry like a tariff entry in the Customs Act. We can't go by the common parlance test. If, as Mr. Dwivedi rightly pointed out, the Gannon-Duncalli test, if there is an expression, whether sale or intoxicating liquor, and that expression has not been defined in the Constitution, then one must see how the existing legislation has taken it. And then what Justice Fazal Ali does is he goes to the dictionary definition, he goes to the common understanding, and he says, no doubt, as per the common understanding, intoxicating liquor is something which you consume. But if you go to the provinces, Bengal, Madras, Uttar Pradesh, Punjab, all the provinces have taken intoxicating liquor to include denatured spirit also. That's what his lordship's view is. And so my first submission, my lord, to save time is, Justice Chagla's observation at page 439 does not contain any discussion about the legislative history. His lordship says intoxicating liquor is a hard drink as opposed to a soft drink. It means only a beverage. Should I take a lordship to that page, my lord?
No, that's
Yes.
The same paragraph.
the same paragraph. We've got just
Yeah.
just
That's
Chagla
all.
also.
Sorry, lordship is saying something, my lord?
We read it in the first.
Yes, page 439. But if your lordship now sees Justice Fazal Ali's analysis, and I would request your lordship to permit me to see that, this thing, because at the end of the day, my lord, now your lordship is sitting in 9 judges. There is, in my humble submission, there is no need to reinvent the wheel and go back to square one. If Fazal Ali's view is acceptable, it has stood the test of time till 1990. The Union of India said it's a correct view. And I will show that the distinction made in synthetics and chemicals is completely not correct, my lord. They simply say Fazal Ali and the bench did not comprehend the possible uses of industrial alcohol. That can't be a ground to say the law is bad. So I'll just first go to Fazal Ali's judgment. Yes, lordship will just come to volume 5 at page 1725.
That is always so.
Lord, it will be PDF page. Yes,
If you
no.
look at, for instance, the one of the key acts that Balsara relied upon was the Licensing Act of 1872.
Yes.
Now, if you just go to the compilation at volume 4B,
Yes.
just to sort of 4B,
4B, I'll just go to.
page 578.
Yes, I'll just go to it. 4B 578. Just
The page number of Fazal.
take it in a volume. Wait a minute.
This is.
Some 4B 578. Just tracing it, Lordship must also see the Spirits Act of 1880 and then the subsequent excise acts. Because Lordship is to see what was the history after up to 1919, there was no such thing, that after that only this problem came up. Now, if your Lordship kindly sees 578.
For the sale by retail of intoxicating liquors
Yes.
and the regulation of public houses and other places in which intoxicating liquors are sold,
Yes.
and to make further provision in respect of the grant of new license for the sale of intoxicating liquors and the better prevention of drunkenness.
Yes. That comes to public. No, I'm not. There's definitely a possible view to say that intoxicating liquor means only beverages for human consumption.
That's right.
But I'm saying that will drastically reduce the scope of intoxicating liquors, and on a ground level, it will be impossible to implement. I'm coming to that as a second stage. My first submission is, please see the observations of Fazal Ali, Justice Fazal Ali, sorry. Does it merit a reversal or an overruling? Kindly see his lordship's discussion. Now, kindly come to Justice Fazal Ali's discussion. Please come to para 38 at PDF page 1731. Para 38 minute. The Bombay Prohibition Act. Volume 5, page 1731. para 38. His Lordship extracts the definition of liquor in the Bombay Prohibition Act. Now, please come to para 39. The Lordships come to para 39. Now, the discussion starts after extracting the definition, which says liquor includes, Lordship will note includes spirits of wine, methylated spirits. Just to pausing here, the UP definition says it refers to spirit, and spirit includes denatured spirit. That is in the UP Act. Now, kindly come to para 39. The High Court has held that the word liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Proceeding upon this view, the High Court has held that although the legislature may, while legislating under entry 31, prevent the consumption of non-intoxicating beverages and prevent the use of drinks of alcoholic liquids which are not normally consumed as drinks, it cannot prevent the legitimate use of alcoholic preparations which are not beverages, nor the use of medicinal toilet preparations containing alcohol. This view of the High Court was very strongly supported on one hand and equally challenged on the other, and I therefore proceed to deal with the question at some length. Then, my lord, his lordship takes para 41. 40 is the Oxford Dictionary. Now come to para 41, and then I'll take a lordship to para 44. Please come to 41. May I read, my lord? Thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning assigned to it in the extract quoted above, that is, a drink or beverage produced by fermentation or distillation. The latter is undoubtedly the popular and most widely accepted meaning, and the basic idea of beverage seems rather prominently to run through the main provisions of various acts of this country as well as America and England relating to intoxicating liquor, to which our attention was drawn. But at the same time, on a reference to these very acts, it is difficult to hold that they deal exclusively with beverages and are not applicable to certain articles which are strictly speaking not beverages. A few instances may make the point clear. In the National Prohibition Act of America, 1919, they quoted, I'll just pause here, Lordship will just make a note. In Salesman, Lordship has got the National Prohibition Act 1919. In that page, in the middle, Lordship has seen that. There, just to pause, the National Prohibition Act was interpreted by the US Supreme Court. And I mentioned in my first argument that they said intoxicating liquor includes denatured spirit. That's what the US Supreme Court held. Now, my lord, please come. Please come to para 42. The Licensing Consolidated Act of England was an act relating to licenses for sale of intoxicating liquor. The definition of intoxicating liquor was as follows. Intoxicating liquor means, unless inconsistent with the context, spirits, wine, beer, port, etc., and any fermented, distilled, or spirituous liquor which cannot, according to the in law for the time being enforced, be legally sold without an excise license. The word spirits, as defined in the Spirits Act of 1880, as meaning spirits of any description and includes all liquors mixed with spirits and all mixtures, compounds, peppermint spirits, it was contended before us that the word spirits in the Spirits Act should not be imported in the Act of 1910, but in our view, for the purpose of understanding the definition of intoxicating liquors, the two acts should be read together. I do not suggest that the definition of liquor in the present act was borrowed from those acts, but I'm only trying to show that the word liquor is capable of being used in a wide sense. And Lordship knows legislative entry give widest interpretation. Now, 44 is the most critical and most important paragraph. Coming now to the various definitions in the Indian Acts, I may refer in the first instance to the Bombay Abkari Act of 1878 as amended by the subsequent acts, where the definition is substantially the same as in the act with which we are concerned. In the Bengal Excise Act, liquor is said to mean liquid consisting or containing alcohol and includes spirit of wine, tari pachwai, beer and substance, which the provincial government may declare to be liquor for the purpose of this act. In several other provincial acts, for example, Punjab Excise Act, UP Excise Act, liquor is used as meaning intoxicating liquor and as including all liquids consisting or containing alcohol. The definition of liquor in the Madras Abkari Act of 1876 is the same as the Bombay Act of 1878. Even if we exclude the English and American acts from our consideration, we find that all provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. the framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of our country, and accordingly, I consider the appropriate conclusion to be that the word liquor not only includes those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but all liquids containing alcohol. It may be that the latter meaning is not the meaning attributed to the word liquor in common parlance, which is what exactly the union is attributing in common parlance, especially when the word is prefixed by the qualifying intoxicating. But in my opinion, having regard to the numerous statutory definitions of the word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor as used in entry 31 of list 2. Then there is, in my opinion, another method of approaching the question which deserves consideration, remembering that the object of the Prohibition Act was not merely to levy excise duty, but also.
Mr. Datar, if
Yes.
just let's dwell on this sentence.
Yes.
Even if we exclude
Yes,
the American and English acts from our consideration,
yes,
we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor.
yes.
If we adopt this test, then the word intoxicating has no relevance at all. It has no meaning at all.
No, now I'll tell you why it is like that. Lordship will kindly see. We are now testing how does the state.
And then see what he says. Accordingly, I consider the appropriate conclusion to be that the word liquor covers not only alcoholic liquids, which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. So liquor may really refer to all liquids containing alcohol. But when the statutory language is, constitutional language is intoxicating liquor, then even though liquor per se may include all liquids containing alcohol, the moment the prefix intoxicating is added, we can't render that prefix a surplusage.
Correct. Now, your
If,
Lordship.
if entry 8 was liquor, that is to say, possible view. But then we would be ignored. But if we apply that test, then why did the Constitution say intoxicating liquor? Liquor would be all liquor, all liquids containing alcohol. Fair enough, as Justice.
Why add the adjective intoxicating? Why add the word intoxicating?
Intoxicating.
There are two answers to that. First is Justice Fazal Ali's explanation that if you go by the common parlance test, then intoxicating liquor means only liquor which can be consumed by human beings. That's the common parlance test. But he says, I'm interpreting a legislative entry, and the legislative practice in India, in British India, has consistently, because intoxicating liquor was there from the beginning, intoxicating liquor has always included all kinds of liquor, intoxicating other. That's a legislative practice. That's what Mr. Dwivedi highlighted Gannon Duncally's case. Intoxicating liquor has not been defined in the Constitution, but intoxicating liquor has been defined in a number of excise acts in the provinces. So when the framers of the Constitution made intoxicating liquor in the Government of India Act of 1935 and in the Constitution, they were using intoxicating liquors as a nomen juris. They were using it as a nomen juris, which meant this is a wide term. It's a legislative entry. It's not a tax tariff.
Which means all liquids containing liquid alcohol.
And so this is
all liquids containing alcohol.
because that was a legislative practice. Every excise act, Bombay Abkari Act, Madras Abkari Act, UP, Bengal province, all say that intoxicating liquor includes everything, because the definition of liquor includes spirit, and spirit will include denatured spirit. So if you take a combination, intoxicating liquor always included. That's what Lordship sees. This is the first reason I'm giving the second reason. This is the first reason. It may be that the latter meaning is not the meaning attributed to it in common parlance, especially when prefixed by the qualifying word intoxicating. Exactly what your Lordship was asking. Why did they add intoxicating? But in my opinion, having regard to the numerous statutory definitions of that word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor. Intended by whom? By the framers of the Government of India Act and by the Constitution. So my first submission is, Justice Fazal Ali's decision is supported by, because it is considered dictionary definition, legislative practice, common parlance test, and on a comprehensive test of all these things, His Lordship says intoxicating liquor must include all. Now I tell your lordship why the second view will become unworkable in practice. If your lordship take the view which the union is advancing, that intoxicating means beverages, ready to make drinks.
No, Mr. Datta.
Sorry.
See, you are trying to say that because in British days,
India, in British India.
the states each had a, act to deal with this subject, and they have taken liquor to contain alcohol, irrespective of whether it is potable or not.
Yes.
Intoxicating element is
No, the
not-
word intoxicating liquor in all these excise acts included everything.
would mean,
Yes, yes.
but if that
Because-
is how,
Huh.
and you are saying that this is because when we are interpreting a constitutional provision, we can't sort of blindly say common parlance test should apply, right?
Yes, yes,
Now, in the entry, so far as entry 8 is concerned,
yes.
and the constitutional entry here, we are talking about intoxicating
Liquor. Until lordship, why? Until lordship, why?
because
But the point
your
is the
argument
whole
has to
thing.
be tested that way.
Correct, correct. I appreciate. The whole thing is we are confusing with intoxicating liquor, intoxicating drinks and beverages. Now, this entry, how does it operate? Lordship has to interpret an entry, keeping in mind the commercial realities. A distillery gets a liquor license. Lordship knows in my chart at page 12, it's either molasses or grain. Of course, it can be cashew, like in Feni in Goa, you make it out of cashew, but it's basically grain based or molasses based. Then you come to primary distillation, rectified spirit. Then you come to extra neutral alcohol. And then you either go to Indian made foreign liquor, that is rum, whiskey, gin, or you go to denatured spirit, which is for industrial purposes. Now, what happens is if your lordship sees intoxicating liquor, I'm saying please don't focus only on the two words. Please see further. That is to say, production, possession, transport, sale, distribution. All that means that the distillery which is manufacturing it makes everything. Because of the peculiar nature of our excise laws, whenever it was cleared for industrial consumption, right from the old excise acts, it had to be denatured. Today, UP whom I represent, when the liquor which I know, if I have to clear 1,000 liters for industrial purposes, I have to pay a denaturing fee of 60 paise per liter. And in the presence of the liquor officer, I file DS6 or DL5, I fill that form and I pay the denaturing fee. Now, if you accept the union's argument that intoxicating means only ready-to-made beverages, then you are completely controlling only the IMFL manufacturers. Because the sugar industry doesn't make alcohol. Many sugar industries, they just make rectified spirits and sell it to whether it's the liquor manufacturers who are making whiskey, rum, etc. Few sugar industries do start to finish. We stop at extra neutral alcohol or rectified spirit. From there, the lorry goes to the IMFL manufacturers. You pay state excise duty, you clear it, and goes. You make denatured spirit, you close. Now, if we accept the interpretation, let us visualize that intoxicating liquor means only to make ready-to-made beverages. Then who controls the distilleries? Will the union step in? Because up to extra neutral alcohol, it is intoxicating. And lordship will kindly see one thing. Let's appreciate one important point. You don't denature alcohol to make it fit for industrial consumption. No. You denature it to make it unfit for human consumption. The denaturing is not to make it as a raw material for paint, varnish, polish, perfume, etc. Because it can be diverted, state loses excise duty because lordship sees for denaturing 60 paise per liter. If it goes for this IMFL, 18%. Duty is huge. In some cases, 300%. Duties are huge. So please appreciate this entire gamut from manufacture to distribution is all ENA, is all extra neutral alcohol. The state controls everything. And you can't have a vivisection of alcohol meant for human consumption and intoxicating liquor meant for this. Sorry, that is not the case. And one more thing I want to submission is that if your lordship gives that interpretation, it will lead to a serious breakdown that the sugar industry, which is making ENA, it is not making a soft drink, a hot drink, as Mr. Chagla calls it, or a ready-to-made beverages. And solicitor said it should be intoxicating drink, as in Article 47. With great respect, no. It will be chaos. So, my lord, and that is why what happens is in the amendment to the Industrial Development Act, they say the line of demarcation is the point of removal. Please read the statement of objects and reasons. They're very well drafted. They realize synthetics and chemicals has created created hardship. And therefore, they say Bihar distilleries gives a better formula, and Parliament decides to accept the Bihar formula. They say, let's go up to the stage of removal. Up to the stage of removal, it is state control. Whatever is denatured is central control, central tax. Let me just see sorry.
Intoxicated?
No, Lord, in fact, in a lighter vein, I was just remembered Justice Krishna's thing of intoxicating. There are 4 stages. I don't know if your Lordship has seen that judgment of P.N. Kaushal.
In Kaushal.
Yes, yes. That is, what is it? I'll tell you, Lordship. I made a note of it. 4 stages are jocose, bellicose, lachrymose, and comatose. So when you start consuming liquor first, jocose is jolly, you're playful. Then bellicose, you become aggressive or belligerent. Then lachrymose, you start weeping, you become tearful. And finally, comatose, you go into a deep sleep. That's P.N. Kaushal's explanatory intoxication. This in a lighter way. So, my lord, I just submit that I would request your lordship to accept Balsara. For one reason, A, it is well reasoned. B, it follows the Gannon-Dunkley came later, but it synchronizes the Gannon-Dunkley test. Words not defined in the Constitution, but which have been given a legislative meaning for several decades, must be treated as nomen juris. So it is not the common parlance test, but it's the legislative understanding of the word which is important. Second reason is,
One second.
sorry. Yes, this. So second reason is it works in reality. If you accept the view that intoxicating liquor includes everything, then the existing system of distilleries manufacturing everything and only denaturing, when does it become less intoxicating? When it's denatured, that's all. Nobody starts making denatured spirit. As I said, denaturing is an offspring, is a child of intoxicating liquor. One baby is denatured, the majority is the. So the second reason is it works in practicality. If a lordship takes the union view, it could lead to serious problems. And only IMFL units will come under state control. Thirdly, and neither the attorney nor solicitors answered this point, in para 41 of synthetics, Mr. Parasaram, who was the then Attorney General, makes a solemn statement that Balsara need not be disturbed. It has stood the test for 38 years. And it is not a statement made in an SLP admission. It's a statement made by the highest law officer, keeping in mind the principle of consistency. And till today, nobody from the other side has said why we are decided to depart from the Balsara view.
What the solicitor was saying was that Just because you take a particular stand at a given moment or a position, you can definitely take another position at a later point. That is what he was trying to say. And he said that I will cite 4 judgments in support of my, this proposition.
True, true. No, the point is exactly. Now, I'm not saying that there's an estoppel. Like I think Oliver Wendell Holmes says, if I need not be consistently incorrect. So I'm not saying no. Consistency need not always be a virtue. My humble submission is this issue came straight front before the 7 judges bench. The Attorney General, Mr. Parasaran, at that time says, we don't want to disturb Balsara. We also agree that entry 8 can include denatured spirit. That's in para 41. So the burden is on the union to show that our acceptance that time was faulty. For A, B, C, D reasons, we choose to take a different view now, and that is not forthcoming. The principle is yes, I can always change my view, but you must justify to this bench why the statement made by Mr. Parasaran is wrong, and now you have to completely.
But Valsara is in the context of prohibition only.
No, Balsara is in the context of interpreting entry 31 is equal to entry
But
8.
in what context? Prohibition,
Doesn't matter. Doesn't matter. Doesn't matter.
Bombay Prohibition Act.
Yes, but Balsara has been followed for 38 years in a number of liquor cases. Consistent, it will not accept this complete somersault, I mean, some complete change in synthetics and chemicals for 38 years. Lord Lordship knows in every high court there are numerous cases on prohibition. Like every time there is some liquor license, there is case after case on prohibition. Balsara was followed consistently. And please see what is the reason of synthetics. Please see para 74 for a minute. Please indulge me in 74. Is this the way, with great respect, are we going to reject a proposition of Mr. Balsara? I'm saying this thing, even assuming Balsara could be today, Lordship can take a better view. I mean, a different view. I'm saying, is it necessary? If one view has stood the test of time, accepted by the union, then unless there are overwhelming, compelling reasons to change it, I'm saying don't disturb it. Now, please see para.
But then synthetics has also stood the time now for 35 years minus this reference.
No, but the point is, as far as synthetics and chemicals is concerned, it in fact, far from settling the law, it unsettled the law, and you had different cases. You had Bihar, VAM 1 on one side, other case on one side, Modi Sugar, Deccan Abkari on the other side. All that is noticed in the Law Commission report. The Law Commission report notes that too. I had prepared a table of cases following the synthetic view, cases opposed to the synthetic view. And if synthetics was followed, where was the need to amend the law retrospectively? The Law Commission notes that because of synthetics, a lot of confusion has taken place and we have to set right the law. And then they make a clear demarcation in para 3 of the statement objects and reasons that it is now necessary to demarcate the jurisdiction of union and states. That's paragraph 3 of the statement objects and reasons. We want to make a clear-cut fence. What is the union's territory? What is the state's territory? And what is the fence? The time of removal. The time of removal. When you remove denatured alcohol, Parliament, GST. When you remove for IMFL, state excise, state laws. That's as simple as that. What synthetic says is industrial alcohol is equal to ethyl alcohol. Lordship, can you see? Synthetics may have stood the test of time, but the fundamental error is they say rectified spirit is industrial, ethyl alcohol is spirit, then they say alcohol means fit for human consumption. There are a series of errors in synthetics and chemicals which led to this 9-judge bench. And that is also well brought out in the referral order of Lalta Prasad. So, but Balsara, nobody has said Balsara was wrong. Compared to synthetics, Balsara didn't lead to divergent views. One pro Balsara view, one anti. No. So I'm just saying that the analogy of Balsara and synthetics may be slightly. Now just see.
to say, it's a composite industry. Industry will make ENA. Partly it will be converted into liquor, partly it will be denatured. So who controls it?
Majority converted to liquor, for liquor, and only part is denatured by adding the denaturing in the distillery itself as per the denaturing rules. Lordship will kindly see every state has got denaturing rules, has got a denatured table. If you want to use for paint and varnish, add this denaturant. If you want to use for this, add this denaturant. And I'll show you the exercise manual of the Kerala in my written submission last, that all the liquor and denatured is one small corner. So to your Lordship's answer, it is composite. Now, if you accept the state that entry 8 is only for intoxicating beverages, then it will not cover a distillery, it will only cover an IMFL manufacturer. The sugar is the industry which typically makes molasses, and then it's a good byproduct for them, it's a good source of revenue to convert molasses to.
In which event, who will control that industry?
Who will control that industry? It was working perfectly well till synthetics came along.
Someone
In a situation like this, suppose it's a composite industry. Partly the ENA is sold for, for IMFL, and part of it is, of course, denatured. In such a case, it's a composite industry. Who controls it then? What happens on the
The
ground?
owner controls, so far as regulatory control is concerned.
Regulatory control.
Regulatory control is concerned, my lord. So far as it is central government's part, the central law will apply. That happens. My lord, local laws applies. There are central laws apply. My lord, in every case this happens.
You can't have two
In,
excise officers in the same
unlimited.
factory.
So you'll have a duality of officers.
Two excise officers.
What happens actually on the ground? Then?
On the ground, my lord. On the ground also, my lord, in all factories, all industries, there is a dual control.
No.
For
And with great respect, utmost respect.
I never go by the innocence on the face.
Mr. Solicitor, on this
No,
we can,
take for example
on this
a
we can
pharmacy.
on this we'll tell the solicitor that you are innocent.
No. Lord, pharmacy. My lord,
You
take,
have some of the industry representatives here.
yes.
What happens? Who controls? I mean, what is the ground situation? Because today synthetics holds the field. Now,
My lord, take for example, my lord,
Who?
if there is someone, my lord,
Is anybody here? Mr. Praveen Kumar?
But I've got the
Find
entire
out.
excise
But
manual.
otherwise, my lord, kindly, please,
Sorry.
if you don't mind. Lord, pharmacy, for example, but there is bound to be state laws, my lord, which are applicable to a pharmaceutical company situated in a state. It would be governed by those state laws. So far as central legislations are concerned, they are also governed, my lord, governing the pharmaceutical industry. But that is the reason why for a company having more than one particular turnover, you are supposed to have a company secretary who is trained, my lord, which law of the state is to be complied with, which law of the center is to be complied with. But that can never be a ground for assisting your lordships, my lord, on the question of constitutional interpretation. Every industry, my lord, take any textile industry, there would be, my lord, there are bound to be state laws and bound to be central laws, and both are to be complied with.
But actually, in such a situation, the central laws are also enforced by the state officials.
That is, my lord, delegated legislature. I am not on that. So that can still be done.
No, apart from the delegated legislation, because our constitution contains that provision, right? That if it's a central law, the implementation of the central law is also entrusted in the states to the state officials.
Certainly.
But the center is a very small complement of officers.
No, correct. But we can't have, suppose, for example,
So say the Industrial Disputes Act, it's enforced by the state officers
correct.
in the states.
Except, my lord, possibly taxation, excise, etc. Few, my lord, subjects, all are implemented by the officials of the state government. They implement respective, or my lord, whichever is applicable, central law or state law, as the case may be.
Article 73. You see, Article 73, the proviso says, provided union executive power, provided, just see 73(1), subject to the provisions of this constitution, the executive power of the union shall extend, A, to the matters with respect to which Parliament has power to make laws, and to the exercise of such rights, authority, and jurisdiction as exercisable by the Government of India. Now, provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws. That's why, and you know, as you rightly said, for say income tax, the Income Tax Act provides for a whole administrative machinery.
Your Lordship, see 256, Article 256.
Lord, we're just
Athar is
to
trying to
save
suggest
time.
that, you know, there'll be, just one
No,
second.
1 minute, but just to save time, we've got all the excise manuals of all the states. There is not a single excise manual which has got a role for a central excise officer to play a part. No. We pay the duty. When it goes for denaturing, we put the excise duty challan and we pay excise duty and remit it to under this.
Because of the present regime,
heading
my lord,
308, it
obviously
goes to
because of the
central
present
treasury.
regime.
State, it goes to state treasury. Excise, all my colleagues are here. In all our distilleries, in all the IMFL plants, it's only the state officer who's present.
Because of this law, my lord, because your law is being
the
settled by your lordship.
the amendment says, the object and reason says, the new law, the state has everything till the time of removal. What is the time of removal?
Can I
Removal of
answer the
denatured
question?
spirit.
You rightly, I mean,
No, I'm saying
at
take the
a right
excise
point.
manual. I'll finish by 4 others also understand. Sorry.
Article 256. Obligation of states and the union. The executive power of every state shall be exercised so as to ensure compliance with the laws made by the parliament and any existing laws which apply in that state and the executive power of the union, my lord, that is corresponding provision. My lord, for example, there is a law made under entry 52 that we, the center, the parliament, wish to regulate coffee industry in a particular way. And the law provides that this would be the formats prepared by the state authorities. This would be the reports to be filed, returns to be filed, prepared by the state authorities. That can be done. Right now, the question is whether that power is traceable to 52 or not. How, Lord, the industry is run in an era or a regime where your lordships are yet to take the call can never be a ground to say that that call may not be taken because we are running it right now in this particular fashion. If your lordships takes the view, this is subject to 52, read with 33, with or without 33, then my lord, constitution will take care of itself. But to say that right now there is no system and only state is implementing is no legal answer to a constitutional question.
Lord, I've got a legal answer to that. Lord, sorry.
Only a minute. Let me complete.
No, finish.
Yes.
Lord, should we give us some time next Tuesday, my Lord, we can't finish.
No, that's Lord, one
Stage
more
of
thing.
ENA, even at the stage of ENA, it is alcohol basically.
Yes.
No, one more thing. Lord, entry 52 says control of the industries. No, control may not be restricted to the control my learned friend is expressing himself to be. That's my officer is there, state's officer is there. That's not the control. Control would mean control by law made by the parliament. The law may say that we would exercise control, we would regulate, we would examine A, B, C, D through the officials as may be appointed by us. And those officers can be state officials also.
So, Solicitor, we can ignore all this. Who actually manages it today, we are not concerned with
Yeah.
that. But question is, what is the meaning of intoxicating liquor? Because take a case of a sugar industry. What will be manufactured will be ENA, which is alcohol, which is intoxicating liquor.
No, it is capable, it can be abused as an intoxicating liquor.
No, ENA, ENA.
Not ENA.
But ENA,
Whether it is,
It's a raw material.
country liquor.
whether grain is used or whether any other fruit is used or sugarcane is used. It is ENA only. And ENA is alcohol
For the
intoxicating
purpose
liquor.
of,
You dilute ENA with water, it becomes.
It becomes country liquor.
Manoj, that's correct, Manoj, but that's not the way in which entry 8 uses it. Entry 8 uses it as
But no,
something which can be consumed as it is.
So, Mr. Solicitor, ENA, who will regulate ENA? ENA is not denatured spirit.
It's not,
It is an
unnecessary.
intoxicating liquor.
Kindly see, the law is clear.
It's not denatured spirit.
My lord, they
Because
have
it is-
confused denatured spirit, ENA, this, that. The law is very clear, potable and non-potable. If it is non-potable, it is state, it is center. If it is potable, it is state. And potable would,
This is going far away.
look, if you, if,
Industry.
Mr. Gupta also rarely, my lord, does this.
The final.
I really have a strong case. Well, there is one more factor in my favor.
Yeah, what is Mr. Gupta saying? Just in 10 seconds.
DNA is a raw material for IMFL.
No.
No?
Raw material is either, either
No, it is the
sugarcane,
basic raw.
cane, etc. You don't get.
This is a fundamental misunderstanding.
But how do you
Wrong.
get ethanol? How do you get ENA?
ENA, my lord, is cleared.
My lord, I'll tell you.
It's cleared as an excisable product.
My lord, when it's denatured, it goes to GST entry 2207. If it is not denatured, it is ethyl alcohol coming under ENA, coming under state law. I put GST entry also there. The GST council.
Only a minute.
That's all.
Only a minute. But let us not be
My lord, one is the-
confused on this. For every kind of alcohol, the raw material is either sugarcane, grain, grapes, etc., etc., molasses, etc.
Correct. So
Thereafter, my lord, what you get is spirit. It can be denatured, it can be any other name. And thereafter, by distillation, you get potable alcohol.
No.
So, ENA,
Sorry. No, sorry, sir, because you actually please.
you should be sorry, but not for this.
Yes. No. So fundamentally wrong. Fundamentally. Yes.
Lord, raw material means from where you get it. You don't, my lord, is it available? Is the ENA available, my lord, in a natural form from where I can get it and I can manufacture, say, whiskey or scotch or some whatever, my lord? No, you have to make ENA, and then that is used as a raw material for the purpose, but for the purpose of making.
But
potable.
ENA is intoxicating liquor. There's no dispute on that.
No
It's alcohol.
dispute.
Yeah, alcohol.
Intoxicating liquor, but my lord, not for consumption,
Right?
not potable.
Why?
You have to do something.
No, we want to understand one thing. ENA is alcohol. So it can be intoxicating liquor.
My lord, when
ENA is
when we
95%
go to,
alcohol.
when, my lord,
Sorry?
It's
my lord, let us
95%
not,
alcohol is ENA.
let us not, my lord, give meaning to a constitutional provision which is unnatural. Lord, when the constitution says, my lord, intoxicating liquor for human consumption mean something which is as it is capable of being consumed.
That's a synthetic.
That's, my lord, as simple as that. Not that it can be converted into something which is, my lord, can I go and say that give me 1 liter of ENA because I want to consume it after adding something into it? I cannot. It's as simple as that.
So therefore, according to you, it will not cover ENA, according to you. Is that
Yes,
sufficient?
yes, it cannot. It cannot.
My lord, I'll make my submission. Yes. My lord, my humble submission is entry 8 covers ENA. Parliament has no role to play. My lord, at one very serious issue comes here. There are totally 168 general entries. 168. 82 entries are with the central government, Parliament. 81 entries plus 97. 82 entries. There are 46 entries in the concurrent list. There are only 40 general entries in the
Only
state
a
list.
minute. Before you start, give me 2 more minutes. My page 53 of my written submission. Lord, just, my lord, it is already filed. Please see, my lord, from where the process starts. It's really unfortunate, my lord,
chart
that
is
the
here.
industry is saying that what
Just
is
one
wrong.
second, and we'll come back to you in a moment. So then that is the solicitor's done.
Yes,
Mr. Solicitor, which page are you?
page
taking us to?
53, my lord, volume 2D.
Starts from there.
Kindly go a page before, my lord, kindly go a page before. Lord, alcohol is concerned, the following details are relevant. Alcohol is derived through a distillation process where carbohydrate, that is sugar or starch, is fermented and then distilled to extract alcohol. There is no other, I'm sorry. Then alcohol can be made from any feedstock which has high content of carbohydrates such as sugarcane, rice, maize, potato, beetroot, etc. In India, alcohol is predominantly made from sugarcane juice, molasses, a byproduct of sugar production, broken rice, damage of food grains, and maize. Major types of alcohols are given below. The rectified spirit. The rectified spirit generated after distillation out of those raw materials, having minimum 95% ethanol content is used only for industrial purpose. It is used for industrial purposes such as users as solvent in paints, industrial chemicals, etc. Then extra neutral alcohol, ENA. This neutral spirit having minimum 96% ethanol content is made by further purifying the rectified spirit. This is used both for potable alcohol and industrial purposes.
Mr. Solicitor, just
Only a minute more.
no difficulty. Otherwise I'll forget the question.
I'm sorry.
Now, extra neutral alcohol, ENA, you say that this is neutral spirit having a minimum of 96% ethanol content, which you produce after further purifying rectified spirit. Then you say this is used both for potable alcohol and industrial purposes.
For
right?
making potable, no, it should be for making. It comes
Used for making, right?
Yes.
Now, in that case, at the point when ENA is cleared, is the stage of removal takes place, and it is removed for the purpose of the manufacture of potable alcohol.
IMFL.
If you don't mind.
IMFL, that is. Right? It is being removed at the stage of removal. Why is it being removed? It is being removed for use in the manufacture of IMFL.
Potable, yes.
Will not that fall within the domain of the state? If it is removed at the point of removal for industry purposes, we want you to respond to it. We want clarity on it. At the point of removal, if it is being removed for industrial purposes, certainly then it doesn't fall under entry 8. But
Not for the simple reason that extra neutral.
according to
Data, sir.
Sorry, Manoj.
Not
we are
to do
getting
this
bellicose.
touch.
Krishna is,
It's indecent. Apart from anything else, it's indecent. You are not, you
Mr.
seem to
Datar
be not
won't do anything
practicing
like
here.
that, you know.
No, Mr. Datar would never do that. I'm saying, I'm telling him.
reply to so many points.
Whenever I argue, that's what he does. So I said it's indecent.
Not Mr. Datar.
No. He would never do it. He would never do it. No, he seems to be not practicing here. Just as a younger brother, I'm telling him not to do this. It's anywhere, before anyone.
Mr. Just say sorry to the solicitor.
No,
General.
it's not in an anger or something.
All right.
This happened 5th time, so
All right.
6th time I just couldn't resist.
He's apologized.
No, that's okay. That's over. Now, my lord, this is, my lord, a product which I purchase. If I am the IMFL manufacturer, I purchase that product. And thereafter, my lord, the third category of alcohol is absolute ethanol.
See,
Also-
just 1 second. But the person. Solicitor,
Would you
your point therefore appears to be that it is only IMFL which falls within the purview of entry 8. Because that is the only thing which classifies as potable.
potable alcohol which can be consumed as
Sure on that. There's a little bit of we're not sure on that, because at the stage when ENA is removed for the purpose, ENA is capable of being used both for potable
Industrial
liquor, right?
for
Now,
making
what
potable.
What happens if you have, say, somebody whose business is dealing in ENA is removing it for the purpose of potable alcohol, namely for IMFL? Can you say that then it will not fall within the purview of entry 8?
Yes, ma'am. May I say the
In your
difference?
submission, it says it will not fall in the stage of entry 8 until a IMFL is manufactured. I'm not sure that's the correct position.
Lord, may I show the difference according to?
Yes.
No, just one second.
Yes.
So is it your case that ENA will not be covered by entry 8 and only IMFL is covered by entry 8? Is it your case?
Yes.
Specifically?
Yes. Lord, number 2, why it is? ENA can be used as it is for other purposes like, my lord, industrial purposes, etc. ENA cannot be used as it is as a potable alcohol. And if you have to undertake some activity or some process to make it potable, that is the distinction. ENA as it is used for, my lord, polish industry, etc., etc. My lord, there are several industrial uses. In this context, please see page 53, the chart. Page 53, my lord, for my satisfaction. Have a look at page 53. This is how it happens.
Flow chart.
Lord, molasses, sugar syrup or grains. This is the raw material. I'm very clear about it. For any process which is subsequent, this is the raw material. Then preparation, that is adding water and enzymes for fermentation plus grinding in case of grains. Then, my lord, comes fermentation. My lord Justice Oak has the...
Yes.
Then comes fermentation, that is time taken up to 72 hours. Then comes distillation, means to remove water and impurities to get pure alcohol. Then, my lord, we get either of these three things, my lord, depending upon the nature. Absolute alcohol, rectified spirit, only to be used for industrial purposes such as paint, chemicals, etc. Then upon further purification of the RS, it becomes extra neutral alcohol.
Now,
From-
we got it. Now, for the purpose of my question, are you all on the same page, page 53 of the
Yes,
chart?
but there
Now, just one second. Look at the right-hand side of your chart, and the three, upon further purification of rectified spirit, ENA, extra neutral alcohol, minimum 96% ethanol, BV. Now, there are two branches. One, industrial use depending upon market conditions or alcoholic beverage. So your contention is that until it becomes an alcoholic beverage, even at the anterior stage, it falls outside the purview of.
Not the middle box is wrong. Rectified spirit only for purposes is fundamentally wrong. The middle box. Rectified spirit only for industrial purpose. That is wrong. Because rectified spirit is primary distillation. It can be both. In the old days, rectified spirit was used for country liquor at 26% dilution, 32% dilution. Now with advanced technology, it is in ENA. So it is distillation, RS, ENA. But RS for industrial purpose is fundamentally wrong, which is the same error which synthetics made.
No. Synthetic doesn't go into this.
No.
Lord,
Synthetic says RS is equal to
Lord,
industrial alcohol.
kindly, my lord.
This box is wrong.
My lord, rectified spirit is used. It's the which tragedies come. Rectified spirit can be used, but its use is a wrong word. Abused. My lord, there are certain elements, my lord, which are mixed.
Sure.
And my lord, when I say depending upon market conditions, well, sometimes the requirement of industrial use Lord, only two more minutes. Lord, industrial use, when I say depending upon market conditions, some, Lord, depending upon the market condition, from the ENA, they make more, ENA, if the demand is more, otherwise it goes into making of. Lord, on the basis of use, Lord, your Lordships may not, Lord, define the term. The definition is, it can be capable of being converted into many things. Lord, rectified spirit is used in making not just country liquor, the hooch also, my lord, the hooch
All
tragedy.
right, we now got yes, Mr. Datar, what do you have to say?
And my lord, my apologies to my friend, my lord, but I got irritated on the sixth occasion, my lord. That's all.
All right.
Quickly, my lord. So, Lordship, I recommend Balsara should be accepted. And para 74 and 77 of synthetics, where they distinguish Balsara on the ground that they did not comprehend industrial use, is not a ground to overturn Balsara. Balsara, consistently, the application of Balsara had created certainty. Synthetics creates uncertainty. I would pray that your Lordship restores the Balsara provision. Secondly, my lord, my submission is intoxicating liquor is an exclusive state subject, not subject to anything. And I want not subject to parliament. The word subject to is not there. So, my lord, ultimately there are 40 entries in the state list today.
We'll just take it down. Because we are,
Go for 5 minutes.
yes, certainly.
40 entries in the state list. And out of the 40 entries, 13 entries are subject to list 1 or list 3. So virtually out of 168 legislative entries throughout, general entries, I'm not including tax. Out of 168 general entries, there are only 40 in the state list. And out of 40, 13 are subject to either list 1 or list 3. So only 27 are left to the states. So my humble submission is, entry 8 should be interpreted to preserve the state's legislative competence in its widest amplitude. When the solicitor, I was just thinking to myself, just a thought came to my mind.
According to you, admittedly, even according to your position, would be outside the field of entry 8.
Outside entry 8, once, not only according to me, according to parliaments after the amendment, once the liquor is removed from my factory, then it comes under parliamentary control. Once it is purchased by the paint factory for making a paint or purchased by a perfume company or by somebody else, I have no control over it. UP government has no control over it. But I'm just giving, suppose for example, I decide, so as a legislative policy, I want to maximize my revenue. I'll say we are not allowing denaturing. Everything should be cleared for IMFL. I can do that. Take Bihar, they'll say no clearing for IMFL, only for industrial purpose because there's prohibition. So right up to denaturing is the state subject. And let us not dilute that is my humble request. I'll come to the next point on Tika Ramji. I just wanted to say that in the Para 32 observation, basically Tika Ramji UP Sugarcane Act was to be ultra virus, IDR Act and Essential Commodities Act. In Para 32, they say even assuming, if your Lordship sees my submission, written submission, which I give.
You made the point, even assuming.
Yes, even assuming. I'm saying it is not obiter. It is Article 141. What Justice Bhagwati is saying is, even assuming 18G is there, unless there is a notified order, the state's power is not taken away. It is not obiter. It is a ratio decidendi. Obiter is something which doesn't fall for consideration. And just as it's a passing observation. Now, further, Tika Ramji has been accepted to be correct law in Belson, 5 judges, and 3 other cases. That's in my written submission. I've given those 4 cases. So, Tika Ramji's observation that unless there's a notified order, 18G doesn't operate is Article 141, good law, not obiter. Now, just see the Industrial Disputes Act in the IDR Act for a minute, and I'll just close my submissions. My Lord, in my written submissions, if your Lordship takes my written submissions.
Mr. Datar, in case you require 5 or 10 minutes more, please don't feel rushed.
Other friends also. I'll take 5 minutes and I'll give to them because
since we are concluding, or if you want to come tomorrow at about 3 o'clock, we can wrap up.
we'll take 5-10 minutes more.
Yeah,
My Lord, what I can suggest, Lordship, tomorrow at 3 o'clock, the others can reply, my Lord.
not there tomorrow. So let's conclude today. We'll conclude today. We'll go a little longer also.
I'm so grateful.
We'll go a little longer, but all of you don't feel rushed for time. We'll go a little longer, no difficulty.
If Lordship wants to take a break and come back also, we'll wait
We'll
here.
do that. Just use the comfort break and come back.
Yeah.
There's an Eid celebration by the bar, but the bar can wait for another 10 minutes.
Yes.
For us. All right.
They definitely know I'll call them a lot. Each celebration. Yes. The lighter way. So, my lord, now what I did was I analyzed this Industrial Development Regulation Act. Now the argument was that 18G per se creates an occupied field. If your lordship now sees my written submission 1O, very interesting. Of all the sections, every section except one section, every section says central government by notified order, by instruction, by notification in official gazette, by rules. Section 20 is the only section which says that on management and control, state law will not operate. Section 20 is the only which your lordship mentioned last time. Once section 20 says that management and control is by IDR Act, all state laws get repugnant. But every other provision, your lordship just see my written submissions. At page 1, it's now 1O. Just take it. Please come to, I made an analysis. Question, but what I've done is I've answered the questions individually. And lordship will just come to question 3, 18G. Now, may I request your lordship to see 18G for a minute? 18G for lordship, can see the Bare Act. We all have read 18G1, nobody has read 18G2. Lordship has got 18G1, 18G1. Lordship has seen one number of times, I won't read it again, by notified order. Please see 18G2. Without prejudice to the generality of the powers conferred by subsection 1, a notified order may provide for A to H. Now, my humble submission is, today there is no notified order at all. So our submission is the whole field is open to states. Tomorrow, my lord, hypothetically, the notified order may cover only A, D, F.
Right.
My submission then is, whatever is not covered will be open to the state legislature. Because the notified order has got a scope of covering a territory of A to H. If Parliament chooses to cover only A, B, C and doesn't touch the others, technically nothing wrong.
Except that 18(1)
Yes.
expressly confers the power on the central government.
Exactly.
Now, where do the states get their power?
No, if the central government doesn't confer it, because entry 18G is.
I have a little,
No,
that's
no.
a little
No, I'll
far-fetched.
tell Lordship
because,
why. I'll
see,
tell
the
Lordship.
central government, before it decides whether to exercise or not exercise the power,
Yes.
has to be satisfied about the conditions precedent which are spelled out in subsection 1. If the central government comes to the conclusion that the conditions precedent are not satisfied and therefore does not exercise the power, the state can't say that, well, I'm taking a different view of the conditions precedent and I'm exercising the power
I don't.
because the central government has
No.
not exercised.
Your Lordship is right. I will not make such an argument. What I wanted to see, what Tikaramji said. Sorry.
That's right.
Only to the
Says that the states can exercise power only under entry 33 of list 3.
Exactly.
Because in respect of a controlled industry,
Exactly.
except for the fact that to the extent to which the field under entry 33 is covered by the IDRA,
Yes.
because now we are very clear that 18G is an exercise of the legislative domain under entry 33.
33. Same language is
Right?
used here.
Therefore, once 18G has occupied the field, then the states cannot say that I will bring about other legislation or exercise power under 18G because the central government has not exercised.
No. I don't say that. 18G is a central act. There's no question of
Obviously.
exercising powers of the state.
So state, you are saying that the state can then enact a law,
No, I'm saying that entry 33 is concurrent list.
right?
So trade, commerce, production, supply, distribution is both parliament and state.
Right.
Entry G, 18G, the power to prescribe except production, they don't touch production. All other things, the state can make a notified order. The argument of the union is once 18G is there, that is enough. according to me, because Lordship will kindly see, when Parliament makes a law, it can either make a law fully, which is fully operational per se, like the Income Tax Act or central like GST, it is fully operational, nothing is required. It can make a law which has to be implemented through a notification, through a notified order, subject to rules. So in that case, the law is still not there. The law, only the power is there, but it's not exercised. I am putting for the.
But except for the fact, conceptually,
Yes.
a failure, or let me not use the word failure, the absence of a notified order by the central government may be an indicator that the central government as a delegate of parliament does not consider it expedient to regulate that particular aspect.
Yes. In fact, I was going to tell you.
At this stage.
Yeah. No, in fact, Lordship will
In
kindly.
which case can the state say that, well, because this falls in a concurrent list subject, though Parliament's delegate has come to the conclusion that it is not expedient to regulate for a variety of reasons, the state will still regulate. That may be a little far-fetched.
No, what I'm submitting is entry 33 must be ready with entry 26 and 27. Supply distribution is open to the state legislature subject to entry 33. What happens is once a notified order comes, it becomes an occupied field in entry 33 and it's a no-go zone for the states.
Until the stage of a notified order, there is no occupied field.
There is no occupied field.
The doctrine of occupied field is not dependent on the administrative exercise of power.
No, I'm only submitting.
It is postulated on the existence of a legislative instrument.
I'm submitting, my lord, the doctrine of occupied field should not be mixed up with the doctrine of occupiable field. Occupied field means Parliament has occupied that field.
It has occupied the field by legislating, not
Sorry.
by providing for an administrative order under the.
I'm just leaving Lordship interpretation.
Conceptually, it makes very difficult.
No, please see conceptually. Please see conceptually. Entry section 20, they clear bar of the states. Now there are many cases, management takeover, etc. is there. Many things of regulation, other provisions are there. We are only concerned with 18G.
Yes.
Only 18G. I am submitting the entry 33 will prevail over the state's power under entry 25 or 26 of list 2. Lordship will just take entry 25 of list 2, which is subject to entry 33.
And
State
26,
list.
26.
Yeah, 26, 27.
Yeah, 26, 27. So trade commerce within the state, production supply within, of course, within the state will be subject to entry 33. So I'm only submitting that if entry 33 has not been exercised by Parliament by issuing a notified order under 18G, my powers under entry 26 and 27 are there.
So long as a notified order is not issued.
Not there, because what I'm submitting is in a law made by Parliament must necessarily mean a law made by, how does a Parliament make a law? It may make a law per se, or it may make a law which is implemented through a notification. If the notification is not there, no. In taxing laws, we say a lot, if the computation provision is not there, there is no charging provision. So if there is no prescribed rate, there is no duty. So I am only submitting your lordship, entry 18G, that's why Tikaramji, I use the word occupiable field.
So, Mr. Datta, is it your contention that today, because there is no notification, state can legislate on subjects touching 18G? Can there be a state legislation dealing with the aspects covered by 18G today?
Yes, my submission is take, for example, milk products. Take entry
Today
27.
there could be a state legislation touching the aspects covered by 18G.
Yes, scheduled industry it can be. So please take the scheduled industry, my lord.
So what you are effectively arguing is this, that if there is no notification under section 18G, the subject falls under 26 and 27 of the
I'm not saying, no, that will be a wrong argument. I'm not making that argument. See, lordship will kindly see the Industry Development Regulation Act covers 39 industries under the scheduled industry. The schedule covers 39 types of industries. Now, the center can occupy that field by issuing a notified order under 18G. It can control supply, distribution, trade, commerce. No problem on that. Today, center has not done it at all.
But your argument postulates that the occupation of the field ensures only when the center has issued a notified order.
Yes.
The answer to that is that the occupation of the field operates at the stage anterior when Parliament has legislated.
No, that's the point I'm making. I'm saying Parliament can occupy the field. It's an occupiable field. Please see the schedule. Please
it's an occupied field.
No. My humble
The
submission is.
implementation
No,
cannot be equated with the.
no,
persons who-
Lordship will just kindly see if my.
We'll consider it, but that's a.
No, Lordship will just.
All right, one last point on what the solicitor was saying, and then we can ask the others to argue. On at what point does the jurisdiction kick in?
Yes. No, just see the schedule for a moment.
Yes.
Now let's take, for example, take entry 27.
The last part may not be a very correct.
Anything else left on written submission? Now, Lordship will kindly see entry 27. For example, food processing industries, canned fruits, milk foods, malted foods, flour, etc. Now, 2 points I'm going to make here. I'm saying that suppose there is no notified order with regard to milk foods or canned products. Why can't the Tamil Nadu government, or let's say Maharashtra government, make a law regarding distribution of mango, say, for example, regulate it within that state? There is no notified order. But tomorrow Parliament says that with respect to canned mango slices, this is the law. Maharashtra's power is gone. That's why I use the word occupiable field and occupied field, because there must be, that's why Tekaram says there must be a repugnancy in fact, not a de jure. It should be in fact. Otherwise, what will happen? The danger is Parliament will make a law under entry 3 and never implement it. You will paralyze the state legislatures. And if your Lordship kindly sees, there are 46 items in list 3. Technically, Parliament can make a law with respect to any of these lists and not bring it into force.
No, but food industry, it is a declared industry.
Exactly.
The Food Safety Act.
No,
FSSA, it's
no,
a declared industry.
No, I'm on a different point.
352, it is a declared industry.
Understood. Nobody disputes that. I'm answering my Lord Chief Justice's question. That is it your case that a state can make any laws with regard to these scheduled industries? My answer is yes. Say, for example, take, for example, glass, ceramics, timber, plywood. The state can regulate timber, but if there's a notified order, quit timber, then I have no power. But if there's no notified order, why can't me within Tamil Nadu or Maharashtra make laws regarding movement of timber products? And the whole irony is the surprising thing, it's now become a center state issue. This act from 1979, there is no rule. We are arguing on a law which is not being implemented at all. The strangest irony is that after 1979, Lordship will see at the end of the footnote, there is no rule made under this act after 1979. In the 2019 Lordship, only 4 items are now regulated.
For licensing.
For licensing. This is only licensing. So what is legislatively progressing, they want to bring it back judicially in the reverse gear. With great respect, we should not do that. If Parliament has chosen, it has made the law. It has chosen not to occupy the field. It's saying the states, you please do whatever you want. We respect your autonomy. But if there's some emergency, I will step in and regulate food, soaps, timber, etc. No problem. But I am saying today that if there is no 18G
Even
order,
those industries which have been exempted today, they can always bring back.
You bring it back.
The exemption can be withdrawn.
we don't know what will happen tomorrow. Lord. Suppose there's some serious deforestation.
Yes,
Yes. Who thought of COVID? Yes. So the final point I'm making.
State will be acting under entry 33 list 3.
No. So the state will be acting under entry 26 or 27. What I'm submitting is when the state is regulating, let us say, for example, Maharashtra mangoes. Suppose the state is regulating the canned fruits, fruit products or milk products in Bombay. It will be acting under entry 26. Show that. 26 or 27. Trade commerce within the state, production, supply, distribution of goods. The Lordship said goods includes raw materials.
Center
Until 33 kicks in. So 26, 27 operate full vigor till a notified order kicks in under 33. That's my humble submission.
Point when
Yes.
what the attorney or the Solicitor General was mentioning, he said that, well, even it's only in respect of potable alcohol.
Yes.
And even the stage of ENA, that states have no power at all, he said. That part you may want to respond
Yes.
to.
Yes. My humble submission is,
Yeah, the chart which he showed us at page
yes,
53.
but I have given my chart at page 12.
Last
What I've-
page of your submissions.
Yeah, page 12, I've given my chart. And in this latest submission, kindly see the last page again. Again, the last page is a chart. In the latest submission, which I've
Yes.
where Kerala manual have shown, everything is controlled by the excise manual. Please see the last chart. All these are portable. This corner is denatured spirit. Everything is within the excise manual. It's under chapter liquor. What is happening in portable alcohol is, as per the law commission and as per the parliament is, once it is portable, it is exclusively state's domain. If it is non-portable, it becomes a center's domain. When does it become non-portable? When it is removed from the factory after denaturing. And that denaturing must necessarily be controlled by the states. It can't happen otherwise. Because it's for the state to decide. These are all, as your lordship, this is Oak rightly pointed,
Of your chart for a moment.
which the latest
The chart,
Kerala excise manual. So this is liquor.
no, the chart that you have given in your last.
1-0, 1-0.
One more.
Your latest arguments.
Yes, yes. Not except denatured spirit, ordinary special, everything else is portable. Or fit for, or it can be for human consumption. It's a red box in your lordship's color, I think. In mine, think it's black.
So according to you, except this denatured spirit, everything is intoxicating liquor.
No, denatured spirit is actually intoxicating liquor, but it becomes unfit for human consumption. It doesn't cease to be, lordship will kindly see.
It is also intoxicating.
Yes, because if I add methyl alcohol, I'll go blind. But if I add some other denaturant, I won't go blind. I will become sick, but I can get my kick or whatever I want to drink it.
Not used for drinking.
So the hooch strategy is only when you put methyl alcohol, because that illegal person doesn't know what is the denaturant.
The crimson color that you have put on the right,
Yes.
that is on denatured. I think it should have been put on the left side of the column.
No, I just wanted to say.
And what about rectified spirit? You say your topmost column is foreign, fermented,
Yes.
and
No.
distilled.
Yes,
Then
but-
distill takes us to whiskey, brandy, rum, gin, vodka, rectified spirit.
Rectified spirit.
And rectified spirit, actually, this rectified spirit should come on top near country liquor, because rectified spirit diluted with water becomes this thing. But this is the manual which they are given. What they have said is, what are the types of liquors? What are the types?
Spirit is
Country
not
liquor is of two types.
No, it's not portable
Not
at all.
portable.
Which one?
Mistaken your chart. Rectified spirit is not portable, Mr. Datta.
Rectified spirit is the most portable thing.
Most portable.
And what I'm submitting, why I gave this chart was.
22%
so that
of volume.
Control is by the state government. Purpose was. Lordship will see page 12 of my chart, or the first chart which I gave in my first submission, where I said rectified spirit is primary distillation. ENA is secondary distillation. Both at primary stage and ENA stage, till 90s, it is only rectified spirits. We used to make it, there are two brands UP used to sell, 26% concentration, 32% concentration with a color added to it. It was only rectified spirit diluted with, brought down from 90% to 26%. Now, because of modern technology, it become extra neutral. What do you say when you say 95% alcohol, what does it mean? If you got 1 liter of ENA, only 5% is water. 95% is alcohol by volume. So, ENA now has taken the place of rectified spirit, and I'm told by the association that except Maharashtra, most of the states want to convert only ENA to a country league.
We are intervening because for the International Spirits and Wines Association, but purely on facts, because in common parlance, the words which are used is undenatured ethyl alcohol and denatured ethyl alcohol. Lords, undenatured ethyl alcohol is ENA, which as it is, is potable, which is used for a potable purpose. Lords, I buy around my share of IMFL produced is around 50% of the entire Indian market. My Lord's input is ENA as it is, which is coming to my factories, getting bottled and being manufactured, for producing IMFL. Now, undenatured has to be treated with denaturants so as to make them denatured. Once it is made denatured, all my bottlers have common plants. What happens is, there's a common distillery. The common distillery will manufacture both ENA my lords, once that ENA is manufactured, my lords, then a denaturant is added. There is an excise officer who's sitting there. I'm paying a license fee. I'm taking a license from the state authorities. A fee is paid. Then, my lords, it is being cleared. And my lords, once it is being cleared for, my lords, the paints, etc., then, my lords, if it is used for industrial purposes on self-assessment basis, my lords, I'm paying a union excise duty. Otherwise, my lords, everything is under the
No
state.
GST. And Lordship, now from 1968, we got self-removal procedure. There is no officer present, but for state excise officer is present. But I clear this, and whatever goes for denatured, that goes to central excise thing. And my friend said that GST central excise, earlier central excise will be shared by the states. Now GST is centered by centrals.
And all these are composite plants, just to give this.
ENA,
the product is
told,
finally,
if you
95%
consume
is
ENA as it is, you die. It's toxic, it's poisonous. My learned friend says, Lord, it can't even be
My friend is
smelled.
going back to this beverage for human
It's not,
consumption.
Lord, that,
No, please. Lord, rectified spirit is.
yes, therefore it is used
No.
as toxic in synthetics.
No, but today, even today under the amendment, rectified spirit is portable alcohol. ENA is portable alcohol. Under the GST, what is not portable is denatured spirit. Only when the denatured is added, it ceases to be portable. Otherwise, everything else is portable. Let us not, otherwise we'll come back to the synthetics confusion. Everything is portable. Only thing is what happens is you can't consume it fully. You have to dilute it and use it. Not even for example, just to take, I was speaking to some doctors. Why do you suddenly get an intoxication? If the volume and the speed is very high, you get completely intoxicated because the liver can't metabolize it. That's why you get drunk. But if you take 30 ml and drink it over 1.5 hours, nothing will happen to you. That's the whole problem.
That's
Everything is
IMFL, not.
so my lord, just to summarize, I would say, my lord, now what's happened is if my state's argument is accepted, the industry which is making alcohol, ENA, will neither be under state control nor central. That's the paradox. So I would only humbly submit that please restore the Balsara position. Tikaramji's good law under Article 141. I would request the Lordship to consider this theory of occupied field and occupiable field. Secondly, Mar Aprem Kuri has to be overruled. Because Mar Aprem Kuri did not consider Belsen sugar. Belsen sugar says, till you bring it into force, it is not law. It's a 5-judge bench. So Mar Aprem, apart from being per incurium, not considering a coordinate bench,
Marapuram is 5 judge again.
coordinate bench should have considered it. And Lordship will just see the danger to federalism if you have the theory that just making a law eclipses the power of the states. The power of the state is eclipsed or taken away only, not only when the law is made, if that law requires a notified order or the law requires a notification or a rule, that complete process must be done. Only then occupation takes place. Deeply obliged.
Thank you, Mr. Datta.
Don't worry about it in case we have used a high decibel because it was.
No, between us, there are never high decibels.
Yes, sorry.
My lord, would your lordships be taking a break now, my lord, or should I start?
No,
I can finish in 10.
Yes, we'll continue.
Will. My lord,
Just suggesting what should be left. We need about 10-15 minutes. Like,
Financial implications for all the states. Huge, huge.
this
Because
attention
after
has been
synthetics, we are
taken
not able to collect any vent fee.
At 4 o'clock, my lord.
Take a 5-minute break and come back, I think, because Tuesday. Come back in 5 minutes. We'll just take a small break, just a comfort break, and we'll come back. We'll hear you and entertain themselves until we arrive there.
But in case I'm not there, I'll try to be here as much as I can.